Good afternoon, and thank you so much for joining us for our third ethics series of the year at Massey College. My name is Arvind Krishandhal, and I'm a junior fellow here at the college and a second-year PhD student studying public policy and Canadian politics at the University of Toronto. Before I have the opportunity to acknowledge and welcome our distinguished panelists, I'd like to take this opportunity to acknowledge the traditional land on which we are gathered on today. On behalf of Massey College, I acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is still the home to many Indigenous people, First Nations, Inuit, and Métis people from across Turtle Island. From my immediate left, we have the Honorable Julie Thorburn. She was appointed to the Ontario Court of Appeal in June 2019 and was appointed to the Superior Court of Ontario in September 2006 and Deputy Judge of Northwest Territories in 2009. Prior to her appointment to the Court of Appeal, she was the team lead of the Divisional Court. She is a graduate of the University of Montreal and Queen's University and the Hague Academy of International Law. She also holds an ARCT in piano performance and the silver medal in voice from the Royal Conservatory of Music. She's a member of the board of directors of the International Association of Women Judges. Welcome.
Thank you. And a senior fellow at Massey College.
Yeah. Most importantly, a senior fellow here. Welcome.
Thank you.
Next, I have the opportunity to welcome Cara Hart. Cara is the Chief Executive Officer of the John Howard Society of Peel, Halton, Dufferin, where she leads a team dedicated to reducing crime and building stronger, more inclusive communities. With 2 decades of service, Cara has supported the organization's evolution from early grassroots programs to regional leadership in justice, rehabilitation, and community development. Cara's passion for justice stems from her belief that communities thrive when compassion and accountability coexist, that solutions to crime should be based in research rather than fear, and that the root causes of crime are societal issues that require a collective and compassionate effort to resolve. Welcome.
Thank you.
Finally, we have Ikran Jama. Ikran is a third-year law student. After completing her bachelor's degree in criminology, international relations, and African Studies at the University of Toronto, she earned a Master's of Science degree in criminology and in refugee and forced migration studies at the University of Oxford as a Rhodes Scholar. Her research examined how legal frameworks disproportionately affect the lives of Black, immigrant, and refugee populations in Toronto. Passionate about access to justice, she has supported marginalized individuals in defending against criminal charges through her work at Downtown Legal Services. As a 2-term president of the Arts and Science Students Union, she's represented over 27,000 students and now serves as the most recent alumnus on the Dean of Arts, Sciences, and Advisory Council. And have the pleasure of introducing the chair of the panel, Tom Axworthy, who's also the co-chair of the public policy program here at Massey College.
Good, thank you. Thank you, ladies and gentlemen, for joining us and our distinguished panel who've just been introduced. The ethical issue we're discussing today is one that is being discussed not only in the courts, but right throughout the politics of our country. And that's the perennial issue of justice delayed, is it justice denied? And it's particularly opportune to be discussing this problem this morning, as Justice Thorburn has just told us this morning that the very important Jordan decision of the Supreme Court, which put significant pressures on the provinces and federal government in terms of court administration and the efficiency of our courts, that if criteria were not met, those who had been charged would be released. There have been newspaper stories that possibly up to 10,000 of those who had been charged might be released because of problems in meeting the Jordan decision, which there was a hearing yesterday, and the Supreme Court, you said it was about an hour, a relatively short hearing, but that highlights the issue of the efficiency of the courts if those who have been charged are being released without the cases being heard. So this is a very topical and critical issue for our judiciary and our politicians to agree to. So I want to begin by essentially posing to each of our panelists one basic question to kick off the discussion. And we'll talk together for about 40 minutes or so, and then open up to questions to the audience, both with us here at Massey and online. And that question is, from your differing perspectives, as we've heard through the introductions, what do you see as the single most important barrier to the goal of a timely and fair justice system in Ontario today? And I'd like to begin with Justice Thorburn, who I should also mention, her father was my favorite professor at Queen's University, taught me politics and government and the law. So if I make any mistakes today, we'll blame your dad, okay? Justice Thorburn.
Thank you very much. Well, you know, they talk about justice as being the first virtue of social institutions, and I think justice is really, really important. We see this in countries all over the world today. But I don't think you can give one answer for what is the most important solution to get the best type of justice, because I think there are three considerations. There are costs, there are delays, and there's a just result. And the three parts have to work together in order that we have a just system. So I know that the focus in the last little while has been on delays, and as I mentioned just a few moments ago, the Supreme Court did hear a case that followed up on the Jordan decision that was delivered many years ago. The Jordan decision, of course, set some guidelines for trial judges to say when is it too long, such that charges must be stayed. And in cases going to the Ontario Court of Justice, the provincial courts, it was 18 months. And for cases going to the Superior Court, it was 30 months, unless there were exceptional circumstances. The problem was, what are those exceptional circumstances? What constitutes exceptional circumstances? It's not entirely clear for trial judges what that means. And so the federal government and several of the provincial governments sought to get some clarification from the Supreme Court yesterday. It was a case that involved a particular individual. What the court did decide to do was to send it back for trial and not to stay the charges, but there weren't comprehensive reasons which some people thought they might like to have to make it a little bit clearer. And of course, there are also the issues, as I'm sure my colleague will mention, about access to justice and making sure that things are done not only in a timely way, but in a cost-effective way. And we've got more and more self-represented parties, particularly in the civil context. They don't have either the familiarity with the legal system, nor do they have the funds that some others have. And so that is a real challenge. And then, of course, there's the issue about judicial resources. Do we have enough judges? We don't have as many judges per capita as we used to have. Do we need more? Do we need other systems? Do we need case management, for example? And I know that certainly in the civil context, our current Chief Justice of the Superior Court, Jeffrey Morowitz, and the Attorney General for Ontario, Doug Downey, have decided that we need a real overhaul of the civil rules of civil procedure in order to address delay, costs, and expediency in the trial process in order to get a just result. So there's going to be a major overhaul of the rules of civil procedure, and I can get into what that really means in a few moments, but I don't want to take all the air from my friends, so I'm going to pass the torch to them.
For our online audience, when you talk about civil law, that's essentially people suing each other
Correct.
privately.
Correct.
It's not the
Correct.
criminal.
They're
court.
not criminal charges that where the state is charging somebody with a criminal offense, but rather an individual or a corporation decides to sue another individual or corporation.
Karen, from the John Howard Society, on your recent report, you talked about a lot of barriers, so so please give us your wisdom.
So for those who aren't familiar with John Howard Society, we're a nonprofit organization that sits at the crossroads of social work and criminal justice. Many of our programs focus on different areas or different stages of criminal justice. Our most recent report focused on bail, and in particular the growing delay and overburden of that system. And so from our perspective, the major issue we see with a delay in justice and what may be causing those barriers is that the justice system is being used as a solution to a number of social issues, which it was never designed to solve. So it's being used to address mental health, addiction, homelessness, poverty. And these are individuals who don't have the resources to navigate the system well, which means they're often remanded into custody, and they sit in custody and come back to court repeatedly. Or if they're in the community, they don't have the resources to navigate the system and address their criminal matters effectively and efficiently either. So we spend a lot of time in our programs, and particularly our bail program, addressing these social issues. And it's our perspective that many of the people who are bogging down our criminal justice system with repeated remands and not being able to move their matters forward are people who could be supervised in the community and given robust wraparound services, which would prevent further criminal justice involvement and thus relieve some of the burden on the system, but also that this community-based programs and supervision can take some of the overburdening of the system away as people move through the system. And we do this in a number of ways. So we have diversion programming, which takes someone who's starting down the path of dealing with a criminal justice issue, and we address that criminal justice issue with social programming, counseling, anger management, theft prevention, and take that burden off the system so that the system can focus on the people who need to be incarcerated because they're a risk to social safety, or those who need to go through the proper criminal justice channel because their charges are more extreme and they could pose a danger to society. So we believe that upstream issues or upstream solutions would take some of that burden away. But right now, it's a catch-all, unfortunately.
And is the hope that with the public worry about criminality and the problems you're stating, so many of them are socially based, that our decision makers might put more into the social or the mental health part of our society rather than just letting the justice system deal with that?
Yes, it is far more cost effective, and the end result is much safer for the community when the investment is made upfront socially. That's not to say that right now the criminal justice system doesn't need an influx of investment. It absolutely does to deal with the problem we have currently. But if you want a long-term solution, it really is upstream. The vast majority of cases we see come through are not violent and could be adequately supervised and dealt with in the community rather than in the system itself.
What's your perspective on this overarching issue of justice delayed?
Well, I fully agree with what Kara has just said, and
Okay.
I also kind of want to talk about the social aspect as well. My research when I was doing my master's focused on youth incarceration and rehabilitation. And Kara, you spent some time right now talking about the before, and I think just to add, I'll talk about what happens after the fact as well. And the youth that I spoke to and worked with spoke a lot about how they would find themselves just coming back into the system. And so when we're talking about this, when we're talking about the criminal justice system, oftentimes what comes to people's minds or this immediate punitive kind of notion that we need to, it's become so politicized that we just want to punish without recognizing that that might not be the most effective way of ensuring that people don't come back within the system. It's not the most cost-effective way of ensuring. So through my research, what I looked at is how do we support people, not just coming through the system, but after the system as well, so that they don't come back. And a lot of the youth that I worked with talked about the barriers that they encountered leaving the system, lack of employment opportunities, educational opportunities, the stigma that is associated with being an offender, labeled as an offender, and the intersections of that with poverty, with race. And so I think, when we're talking about justice delayed, it's important to also, when we're talking about the kinds of resources we can pull into with those social aspects, we should talk about also what happens after the fact. Providing more resources to support people leaving the system, I think, is also very, very key.
Well, just on that point, which we can take as a given, the mental health challenges, the social challenges, and the background, all of that.
Yep.
Still, and bail has been mentioned, so this is such a flashpoint, but in my home city of Winnipeg, for example, as there is in every city, but a series of really terrible crimes by repeat offenders who are out, and so much so that our mayor is saying that on his podcast, they will every week announce, a further, some call it a dereliction. What are we doing allowing these people out? So the public anxiety is really there. Mm-hmm. Now, how do we begin to address that when you have a public so overwhelmingly concerned about safety and repeat offenders happening not just anecdotally, but so often?
You start with statistics.
Yep.
Okay, well,
I mean,
give us
honestly,
some.
If you say, if you say the crime rate has gone up, the violent crime rate has gone up, or it's gone down, or whatever, you look at that, and I think you also look at, you people would know this better than I do, but international comparators, look at rates of recidivism, what happens when you do X. I think data speaks volumes, and if you say that, this was tried, this was how it was funded, this was what was done, and these are the results, that's very compelling. Because I think we need to get away from whether you're soft on crime or tough on crime and start being smart on crime. And being smart on crime is looking at data, isn't it?
Yeah, just to add to,
Mm-hmm. Well, and then we'll go to Kara. Yeah.
Just to add to that point, there's no data that the government is offering with respect to how many people are granted bail and then commit an offense. We don't know if there is an issue here. We don't have the statistics or the numbers to show for that. We have anecdotal evidence, and we have the media that puts this into the public's minds, and of course it will, because if something happens, it's sensationalized. But we don't know if this is actually something that is a problem without the data, without statistics.
And why don't we know?
Well, we don't have studies or information. We just don't have that, and I think it comes into. I think it's just. When we're looking at this from an academic perspective, it's, well, who's putting money into this and all of that as well. And but it would be helpful to actually know if this is a problem or if this is something that we're just seeing through anecdotes or through the media as well.
We do have data though about are crime rates increasing?
Yes.
What kinds of crimes are increasing? Statistics Canada does keep those
violent
things.
crime, they're going up, and so
we do
on.
have some data.
So if we have that kind of data, what is the data that we're missing on this data point that you raised that we need? So what's missing from the data picture if we don't want to sensationalize things.
I guess the answer is we know what crimes are being committed, whether there's an increase in certain types of crimes or whatever over time.
Right.
Do we know how many people have not gone on to commit more crimes if X happens? And I mean, I think that is a problem. And I think if we're looking at international comparators, I mean, what are they doing in Scandinavia? What are they doing in Germany? What are they doing in South Africa? Well, wherever. And are there things that have worked? And then you look and see, is our society, have we got other challenges, different challenges? Are the makeup of our peoples or whatever different? And if so, how? But I mean.
Mm-hmm. Kara, on the data issue,
Sure.
if you have a
Yeah.
point of view. Yeah.
So there is a wealth of information regarding how the international community has dealt with similar situations. And really, when we look at the most effective countries who are dealing with crime across the spectrum, it's social programming. And when you look at the bail program, because that's my expertise, so I'll speak from there, is that the success rate of the bail program across the province is 80% and over, which means that the vast majority of people who are on bail, and in Peel, Halton, Dufferin alone, we serve over 2,000 people a year on that program. The vast majority of people are attending all court appearances and not offending while they're on the program. And with the overburdened justice system, you can imagine that we have people on the program for years at a time. And during that time, they're receiving social programming that is designed to reduce recidivism, reduce the factors that are contributing to people committing further crime. So again, social programming and addressing the things like lack of employment, lack of housing, lack of positive social relationships, mental health issues, addiction, addressing all of those things is really what prevents people from committing further crime. And if you look at Canadian data, our overall crime rate is way down compared to 20 years ago. We have had a blip, let's say, in car theft or and some violent crime with a peak, I think, around 2022, 2023. But again, car theft has come down again. So we really do need to look at the data. The data is a huge indicator because what we see in the news is absolutely sensationalized. These are not the typical people that are working their way through the justice system. They are a minority of examples that make good news. And those are the people that the system needs the space and time and resources to deal with within the way our system is designed now. But unfortunately, that's not the case.
But of course, for those of us in the administration of justice angle, there's also, we have to take into account the victims as well.
Absolutely.
And so there are real challenges in deciding how dangerous is somebody, and if we let them out, and however terrible the circumstances are, and they often are terrible, that person has lived in their life, there's also both potential victims and victims or people that are claim that they are the victims of particular things, which is why they're in front of the courts in the first place. So it is a real challenge, that balance and finding the right balance to make sure that there is confidence in the administration of justice from all angles.
Absolutely.
Sure. Can you describe for our audience then on the bail issue that our federal government, Mr. Carney's government, has just brought in a series of reforms, quote unquote, at least changes in our past administration of bail, and the premiers have called for even more, tougher, quote unquote. Julie just said it's not just a question of being tough, but that's what they came up with. Can you give us an assessment of what has the federal government proposed? Is it sensible? Is it adequate? Is it getting the balance more in line that we've just talked about?
We have real
The whole panel can comment, but I want to begin with Karen.
Sure, we have real concerns about some of the suggestions that are coming forward, particularly with cash bail.
Although that's not federal. That's provincial.
Oh, is that provincial? Okay. So we're talking about then the onus, reverse onus, and
Reverse onus, yes.
increasing who has to argue reverse onus. So I would go back to, again, the resources that people have for adequate representation in court to be able to present a case and develop adequate release planning. When people don't have the resources to navigate and make those arguments based on law, or have the resources to reach out to the community and develop a safe case for themselves to be released, they end up in remand. And our current jail system right now is already overburdened and has been for decades. 80% of people who are in custody right now are on remand and have not been convicted of a crime. They're waiting for release. Many of these people are appropriate to be incarcerated, but we also have many who are not. They are people who don't have access to surety, which is someone who can bail them out and supervise them in the community. They don't have access to housing or adequate release supervision. So I think if we're not careful with how the legislation is applied, we're going to exacerbate an already precarious situation.
Other comments on this point? Fran, do you have?
My comments on the reforms right now, the main concern is obviously what we're doing is we're holding perhaps innocent people. We don't know if people who are seeking bail are guilty or innocent, but we do know that we will probably see an increase in perhaps innocent people being held. And I think that raises a lot of charter concerns. And I think my second point is the disproportionate impact that this would have on particular communities. Looking at Black communities, Indigenous communities, and what that would mean for these communities and how they view the justice system as well. And I think there would be significant negative impacts in how these communities not just see the system, but encounter and go through the system as well. And so I think when we're looking at these kinds of changes and they call them reforms and stronger on crime, again, we're not sure if we're actually holding people who have committed a crime, but the negative impacts here are very real for these kinds of communities as well.
But the government argues that the particular onus is on repeat offenders, and it's particularly on the repeat offenders who must now reach a much higher barrier to argue for bail. I mean, is that not fair or sensible that somebody who has already been committed of a crime should have a particular onus put on to argue why bail should be given? That, i.e. the repeat factor, obviously, at least in my common sense view, has an impact on the public safety factor, which is also part of the bail system. Is that fair or unfair? Throw it out.
It's a complex question because it's a very case-by-case scenario. And I think when we're talking about repeat offenders, I think we also need to look at what was their previous release like, and what was in place at that point. Have they had an opportunity, or have they had adequate interventions? And if they haven't, then I think that needs to be taken into account. An offender who has had lots of opportunity and continues to commit crime repeatedly, that's a fair onus that they should have to argue. But at the same time, we may be putting innocent people in a correctional facility that's not effective to deal with the factors that are creating this recidivism cycle.
On the
But I would say that the fact that you've committed 20 crimes before would have been considered in any event. I mean, if you're saying so I do think we need to think of both, and from my standpoint, somebody would be looking at these things, you have to look at balancing things, and the community has spoken out, the community has expressed concern when these things come out, and I appreciate that oftentimes they're sensationalized, and oftentimes they may be taken out of context. And those are different channels. I mean, that's where the media comes in. That's where, you know, mainstream media and other institutions that are more balanced can come in and give, you know, reflections and things. And that's why it's sad that social media has sort of taken over, where there's just one perspective as opposed to giving a more balanced view of, on the one hand this and on the other hand that. Those are concerns. They're not legal issues, but they are concerns about the perceptions of people who view the administration of justice. And frankly, our system of justice is only going to be as good as people who have the confidence in the justice system. And everything you people have said is very valid, but that's the other part of it, and that we all need to take into account, that people feel like there is something being done when there are people that are very, very dangerous that could be led into the community because they've had challenges in the past. So I think we really have to take a long and hard look at the individual and say, how dangerous are you? And there are other technological things. There are ankle bracelets, for example, that will allow us to say, well, you know, you'd know exactly where this person is at any given time. And it's not 100% because A, sometimes they can cut them off, or B, sometimes they've done whatever terrible thing already, even though they're wearing the ankle bracelet. But modern technology has given us other tools, I guess is what I'm saying.
Now, part of the series, and we're on YouTube, is designed for public education. And so we've talked about crime statistics, and comparatively it may not look as bad, or crime has been going down, and so on, and calling for reason and balance. But on this, you know, saying all that is perhaps correct, but recent public surveys have showed that right behind jobs and the economy are fears about rising crime. So we have a huge disconnect between the data that we need more for, and the public perception as measured by polls that this is accelerating. Now, what's behind that conundrum?
That's an excellent question.
Social media is one we've already talked about.
Yeah, I would say media, but and then also the real increase. There has been a real increase in violent crime. There's no
In violent crime.
In violent crime, there's no doubt about that, and I think it's a valid fear. And as Her Honor stated, I think it's really important that we acknowledge that there are people who need to be incarcerated for the safety of the community. There's no doubt about that. And fear comes from, you know, the knowledge that people have, and the place they're getting the knowledge is the news.
Right. Well, we also had, in our earlier comments, talked about court administration and resources and so on. And Ontario has a program, I think it's called, they're great at slogans, but I think this program is called Justice Accelerated. So a spin doctor was good at that program. But they have put money into, if I'm correct, heavily invested in digital platforms, and also major reforms on the civil side, which you mentioned. What do we think about the court administration, the pure efficiency at it? I mean, should we have judges managing their own courts, or should we have professionals, as in hospitals, managing court dockets and that kind of thing? Is the digital issue, video conferencing and not having to put everything on paper, a useful reform? But in Ikran's point, what about a series of minority groups who may not be as digitally literate as the rest of us? Certainly seniors, though they may not commit many crimes. So I'm looking at the substantive steps around court resources and administration, because that seems to be a hard political sell unless you can tie it into the larger crime issue. What do we think about those sets of actions and reforms? Useful, positive? Tell me how the digital system, in theory, is supposed to improve. Ikran, do you know?
Well, I would love to know from experience how it's been like. I mean, when I was doing my research, this wasn't a thing. This is pre, most people went in person to courts. But my concern would be this kind of digital illiteracy. I think, it's already very hard to navigate and go through the system. My concern is when we're looking at the intersections of not just race, but we're looking at immigration status, we're looking at, there may be communities that would have a more difficult time going through this. While I was in law school, I had the opportunity to see a few cases go through online, and there were issues, and there were issues. It was difficult for individuals to access, to use to even know when to unmute, when to mute, concerns about their backgrounds. I can see that there would be potential barriers. I can also see how it could actually, though, improve efficiency and how it would reduce costs. But if there are experiences on the panel, I'd love to know how you've encountered this digital world that's happening right now.
Yeah, I mean, you've hit the nail on the head to say that for our clients who are traveling through the justice system, who are working, the digital access to court has been a real benefit because they don't have to miss work. And it's taking, pardon me, it's taking a burden off of them. On the other hand, we have a number of clients who don't have access to technology, who can't navigate technology well, and they're really struggling with that. I'm sorry.
That's all right. Have some water.
Yeah. I'm reminded of when I wrote the LSAT, it was online, and I have a big family with lots of siblings, and how hard it is to find a quiet space as well. That might be something that you've maybe perhaps encountered with people on the move, people with bigger families, people who might not have spaces to.
The other thing is that the justice system wasn't really that technologically savvy itself, and so that was another problem. And I think the one thing that happened with COVID was that we were all thrust into the 21st century very, very quickly. And so, hearings were hybrid hearings, or they were online, particularly at the trial level, and witnesses were testifying online. And while there are challenges to that, and problems with really understanding the seriousness of what's going on, because you get people in the drive-through at the Tim Hortons and somebody's handing them their donut as they're testifying, and you sort of think, well, wait a second here. When you're in a court proceeding, it's really serious. There are serious issues at stake, and I don't mean that to be disparaging about those people, but I think the seriousness of the situation is obvious when you walk into a court proceeding, and there's that formality, which does have some challenges for sure, but also some benefits of people understanding the seriousness of the situation, which aren't the case when you're sort of, on your phone doing that. But I think, access to justice in French is a big preoccupation of mine, right. And Ontario is a bilingual province. We are to provide services, bilingual proceedings in the civil context, and French or English language proceedings in the criminal context. But if there's something like a bail proceeding, and you're in Timmins, and there is nobody this morning in Timmins who can hear your bail proceeding in French, that can be done if you have technology. And so it makes it that much easier for people to get the kinds of services that we are required to provide them. If the technology allows somebody who may be in Ottawa and not in Timmins that morning, but can do the proceeding using technology. So it's a mixed bag, right?
Absolutely.
Bottom line.
It was mentioned earlier as well that in looking at the justice system and the bail issues, and youth in particular, that the absence of any real programs or assistance of any major kind, if you have been arrested and are waiting for trial, particularly in the youth detention centers and so on. Again, there have been stories in Winnipeg about young people being there with virtually nothing happening except talking to other young people and getting even angrier at the system and so on. So is that is that a particular pressure point, and is your experience that this is general, that the programs we try to do in the detention system are again underfunded, don't work, we don't know what we're doing, or we do know what we should be doing, but we don't have the resources? What's the story there? Because that obviously has an impact on whether you create crime again if you get a second chance and someone helps you.
You said it.
Yeah. Okay.
In both the youth and the adult system, the programs exist, but they are under-resourced, vastly under-resourced. Yes. We have some programs that haven't had a renewed budget in 15 years, particularly youth programming. And so you can imagine with population growth and the increased complexity of cases, particularly post-COVID, the resources aren't there to take the number of youth that we need to take to be in the institutions delivering programming like we used to be. So mental health, youth justice, and addiction services were struggling to keep up and pay our staff a living wage, afford staff who have the skills necessary to deal with the complexity of cases we're seeing. So exactly as you said.
So,
But the other issue is when you're in the institutions,
yes.
so you're sent to jail, you're there for however long you are. Is there a program, or are there programs within the system while you are incarcerated rather, that will help you when you get out? So, are there skills like electrical or, plumbing or whatever, something that would allow you, when you have served your time, to do something meaningful for your life, be proud of yourself, be able to support yourself, and therefore you don't fall into that trap when you do get out? So, there's the part about not getting in the first place, but there's also, when you're in, not to lose hope for many, and provide them with opportunities should they choose to avail themselves of it. And there are some programs, but there aren't as many people enrolled as perhaps there could be.
You just remind me that at the turn of the last century, or the start of the 20th century, there was a British MP who was arrested for a variety of crimes and was incarcerated. And a delegation from his former colleagues were making a tour of the prison. And as they went through, they said they were working away at bags. And as they went by, he said, "Benson, sowing, I see." And Benson replied, "No, reaping," But, so they were trying to get some skills there. Okay. Any other last points before I throw questions out to the audience or those online? Points that we've missed or points that you'd like to emphasize? We haven't talked much about minorities and the particular issues that they face in this, if we'd like to hear a little more around that point. Things that you'd like to have another kick at the cat on.
I think
maybe
just adding to the discussion that just happened when we're talking about what to do when people what to do when people are incarcerated, waiting to get out, what to do when people are awaiting their bail decisions. I think an interesting thing that we're seeing now is that community-based organizations within these kinds of racialized and marginalized communities want to have a voice and be able to support members within their own communities. And giving these communities that kind of voice and space, I think, is important, and the resources is especially important. So I looked at Somali-based community organizations that wanted to introduce cultural aspects into rehabilitation and support Somali youth in that way. And I think those kinds of knowledges should also be considered and appreciated more in these kinds of discourses. But of course, as we're talking, severely underfunded already with what we do have in place. So, community-based organizations have faced barriers even entering the scene of being able to be a legitimate source that can support those who seek to rehabilitate and come back into the community. But that is an angle that I'm seeing that I think is important to introduce into the discourse as well.
But again, part of the logic flow, which is interesting to look at. If we know that programs like this work in terms of the interest in having future crime, and crime is one of the largest political issues in the country, and that this is preventative, which makes so much sense. We may need more police on the ground, but the prevention side almost always is kind of a 10-to-1. And yet again, we're missing out on more resources being put where perhaps they'll do the most good if people are really worried about crime. That's a second large disconnect, yes, no?
The issue is always how do we shift the narrative, right? I think it's interesting that if you are from these communities or have experience with the justice system, if you see these kinds of cases come in and out, you have a certain perspective, perhaps. My perspective comes from my upbringing and what I've seen, and so I come in with this perspective of, well, we need to focus on social issues. We need to focus on the root causes of crime. That's what we need to do in order to better the justice system. But if you've never seen a court, been to a court, encountered these kinds of cases, if you're seeing what you're engaging with or where your information comes from is the media or social media, then you'll have a different perspective. And the question is always, well, how do we bring in these kinds of narratives, alternative narratives of people who are saying, well, maybe we should look at the social aspects, maybe we should look at not just crime through a punitive sense, but how do we prevent it? And that's
really, really important.
Yeah.
And there is an organization, it's Ontario Justice Education Network, with which I'm associated, but they do school things. And I think we have a public education system in Ontario. We should have kids from public schools coming in to see the courts, and we have a program where you meet the Crown Attorney, you meet the Defense Counsel, you meet the Registrar, you meet the court reporter, you see the courtroom, and it does bring it alive. And I think those things, and the importance of it being culturally sensitive for people who are already feeling vulnerable and misunderstood or whatever. I think I totally agree with you, but I think that's one way in which we are doing it, and there are many others that we should be doing too.
Yeah.
I also think one of the barriers to people really understanding the importance of the prevention and the work in the community is quite frankly NIMBYism. Often we see people saying, that person isn't part of my community, they don't belong here, and it's really easy to say, let's just lock somebody up once you've dehumanized them. And so a lot of what we do is creating community networks for people, because that's one of the biggest protective factors. And so if we can shift that narrative to say that these are people who are unwell in our community, they are our community members, they're a human being, they have family, they have dreams and aspirations, perhaps that might help, but we've lost a sense of community in particular in the GTA, I believe.
Well, ladies and gentlemen, that's I want to thank the panel for their excellent initial comments, and then just to see if there are questions or comments that people in our audience have or online that you'd like to ask a question or reflect on some of the points made. Anybody have a comment? Sir. And we have a mic coming to you.
One moment, please. Hi, this is just a general question for the panel, and that is, I think every legal system is based on some kind of moral sentiment, or if you want to say emotion. So I know there's been a lot of talk sort of generically sort of blaming social media or the news media, and I can kind of see that to a certain extent. On the other hand, it does really reflect how most people perceive how they're living in an urban environment or the general Canadian, North American environment in particular. So how do you address, or how do you sort of generically, philosophically, address what role emotions, short of obviously vengeance and scapegoating, etc., play or are allowed to legitimately play in a democratic legal system?
We began talking about data and reason, and we've been reminded how often emotion is part of how human beings respond to events. Yeah. Comments, reflections on the question?
I mean, I think Lady Justice is blind, and Lady Justice should be blind. But the real challenge is, how do you get to a justice system that really is blind? And so it's not about sympathy, but it may be about empathy, and it's more importantly, it's about understanding. And so we really have to be careful that there are barrages of information, and now there may be bots with 50 million things coming out that bear no resemblance to anything any real person has said at all. They're just things being shot out into the social media sphere. And I would distinguish actually the traditional media from some of the social media outlets that we have now, because the traditional media, at least the objective was to provide balanced views, and I think that's wise. But I don't think that it should be emotional. I think we need to understand that there are victims who have suffered tremendously and been through trauma and whatever, and they have to be appreciated, recognized, and understood. And I think that accused people, when they're involved in their sentencing, some of the things we need to look at are, not just enunciation and deterrence, but things like rehabilitation, and that requires us to have an understanding, to think and to try to understand that person, where they came from, and why they are the person that they are. But I think it really is, and that takes us, if we do it correctly, I think, to a justice system that is and should be blind, in the sense that you understand cultural context, you understand victim feelings, you understand accused person's background, and all of those things together, and then try. And you know what? We're human. We make mistakes, and that's why we've got courts of appeal and Supreme Courts that tell us when we've made mistakes, which we all do. But we do our best to try to find a just solution in it. And that's, I guess, is what I would say.
Any other?
I strongly agree. I think you can't separate emotion from the human equation. On the same hand, though, in court, you're always going to have opposing emotions. And so I think that's the importance of that almost blind system. And that empathy is absolutely the key. And empathy for both sides. And that is what will bring justice.
We have a question here. Yes.
Thank you. My question was kind of answered already, but it has particularly to do with the importance of being able to kind of intertwine and braid together different perspectives from different cultures, upbringings. But how, and if this has happened, have you seen any issues in intertwining both the victim themselves and also the perpetrator? And the Jordan principle, I'm not too familiar with it if it's particularly only for violent crimes, but have there been issues in kind of finding a balance, if that's even the right way to word it, in recognizing the victim, but also recognizing, the overburdened judicial system with all of these crimes, not even just violent crimes?
Specific question on Jordan, which may go back and then the broader one. Can we just?
Well, Jordan deals with delays, so I'm not sure that's I don't think that has too much to do with bringing the two sides together. But I think that you do raise an interesting point about being culturally sensitive to certain groups. And I do know, I've actually been part of it in the Northwest Territories, where there were, at the sentencing stage, a healing circle. And there were elders in the community, it was an Indigenous community, in the community that would be involved, that have a much deeper and frankly broader understanding of the community than somebody like me, who was flown up from Toronto to look at it. And it's a matter of being humble enough to appreciate that actually you don't have all the answers, and maybe it's a matter of putting in more things into your knowledge basket before you make a decision. But that's one example of what way we do it. And I mean, to some extent, it's individual as well. That's up to the individual person who's adjudicating. But I had a fellow who was accused of crimes, and he was a South American, and he wanted to have feathers put down on the going down to would bring him, I don't know, luck or peace or something. And I thought, you know what, it's not bothering me, it's not bothering my court staff. If it makes him feel really comfortable about the system, it's not going to affect my decision one way or the other. You know, as long as you clean them up when you're finished, then we're fine. And you know, those kinds of things that are small nods that would make somebody in a situation where the structure and the system doesn't change, but the way you try to understand the people within it is.
We have another question at the back and then one at the front. Yeah.
Thank you all for today. I had a question about, so you mentioned how youth resources are really underfunded, and I was wondering if there was a correlation between like people who are being reincarcerated and are repeated offenders, and if there's like a correlation between of them like being like incarcerated when they were youth as well, or when they were part of the juvenile system, and if that kind of like creates a pipeline to them like reoffending later in life.
I wish the system kept that data. One of our struggles is that it doesn't. The systems are kept entirely separate, and for a very important reason, being that a closed youth record shouldn't affect someone as when they become an adult. And yeah, so they don't track someone across systems, unfortunately. Anecdotally, when youth are disengaged from education, from family, and those factors don't change, and they don't have the right supports, when they become an adult, they're at significant risk of reoffending. And there's enough research to tell us that that's the case. So when you're waiting months and years for programming and help, your risk level rises.
Question here? Yeah. Yep. Thank you.
You spoke about bail reform and rehabilitation and so on. I guess to end the conversation, what are some really positive programs in the community that are happening that you'd advocate more for?
So many.
Oh my
You can go down the
gosh.
panel.
Yeah.
Let me think. So your question was in the like.
Things we should be doing more of that are working to change the conversation.
Lots of things. I mean, okay, so I think what is important is having one thing that I think we haven't talked a lot about is having lawyers and representation that kind of understands community members and understands the people that they work with. And I think legal aid is very important in this province. It's severely underfunded to the point where you have lawyers taking on. The last time I looked at the stats was a bit ago, so I won't give numbers, but many cases at the exact same time. So one thing that we need to do more of for sure is putting money into that resource, but also I think it is important when you have people who are by your side going through the system that understand you. And so when I was talking about those community-based organizations, of course you have representation that takes you through the pathway, but it's also important having people just by your side in the community as well that are there for you at every single level and at every single stage throughout once you're out as well. So that kind of an aspect is important, having people within your community or in your corner just supporting you throughout your pathway through the system.
I would say we need far more culturally based programs. There are some great ones out there, but we need many more. Particularly, I would say restorative justice programming, bail. Needs to be expanded badly, and in particular bail beds, so that we can supervise people 24 hours a day and divert from the shelter system, which is a huge barrier to release right now. And then in general, any sort of programming for youth at all stages of the criminal justice system.
I think you two know much more about that than I do, so I will leave it with the two experts here.
Okay, very good. All right.
Aiden's got
One last quick question.
Only if we have time.
Go ahead.
I was just going to wonder if you could comment on the use of AI in sentencing. I mean, there are studies being done on using like AI jurors, but also AI being used to predict rates potentially of criminals reoffending. I just didn't know if you had any strong. Some people are extremely in favor of this, thinking that it could like increase efficiency, but also be more fair, and then other people just think outright it shouldn't be involved at all. So
But you know what? AI is a tool. And it depends on how you use that tool, I think. I'm on the Civil Rules Committee, so we're grappling with the issue about AI in the context of civil proceedings. But I think it's you know, if a lawyer decides to say, look, I can get much more research, much more broad and whatever, if I use AI, it's a tool, it's effective, it lets me do in 3 hours what would ordinarily take me 30, and my client's paying for it, and this matters. You own it. You're an officer of the court, and you own that. And if there's a problem, and there have been problems with people citing cases that don't actually exist and other things, it's a big problem. But I think the truth is, it's here. It's not going away. It is getting more sophisticated, and we on the justice side and lawyers on the other side have to adapt, because it's not going to go away, and people are going to use it. And but we have to use it wisely, and we have to realize that, and lawyers have to realize that as officers of the court, they will own the product, and it's their reputation if they haven't done the due diligence to make sure that, in fact, that data can be substantiated in the way that you say when you present it to the court.
Just very briefly too, I think with respect to, I completely agree, with respect to sentencing also, in the United States, this is something that some states have done, and the research, I won't take an hour talking about it, but I think, you know, when we're looking at AI, we think AI is neutral, but, you know, the data comes from somewhere. It comes from real life. And so what we're looking at when we're looking at research from the United States is that you see people who are marginalized, particularly Black offenders, are having or being given sentences that are much harsher than others, right? And that's because of the data, you know, that was already skewed to begin with coming through AI. So I think that is a danger to consider. I mean, we don't do this yet. We don't have this yet with respect to sentencing in Ontario, but it's important to look at how the research is shaped out in the United States to consider that in this context as well.
Well, I want to thank the panel and the audience for a very spirited discussion on a very large issue. We've talked about, somewhat surprisingly, probably for many in the audience, that there are many important parts of the judicial system where we don't have data. So we don't quite know what we're talking about, and why isn't that being addressed? We've emphasized the preventive measures. We've talked about the disconnect, about lack of resources in almost every domain that we've talked about in this panel, and the disconnect between the public concerns about crime and our politicians' response to them, and then the policy responses and resource responses, which are a disconnect from what the public says they are basically interested in. But we want to end on a positive note. So let me end with Martin Luther King quoting the Hebrew Bible: "Let justice roll, let it be a mighty stream." Thank you very much. Thank you all. That's very good.